Well, hello, everyone. My name is Gerald Morris, and I'm going to be the host of today's podcast. As background, I'm an adjunct professor of law at the Nova Southeastern University Shepherd Broad College of Law. I'm also a Florida Bar board-certified health lawyer and former general counsel to Holy Cross Hospital here in Fort Lauderdale. Welcome to another podcast from the Nova Southeastern University's Geriatric Work Enhancement Program. This podcast is made to encourage, enhance, and promote all those fantastic health professionals working with older adults, including those with Alzheimer's disease and dementia, and their caregivers and support systems. In today's episode, we are taking an in-depth look at elder care coordination with our special subject matter expert, NSU law professor Kathy Cerminara. Now, Professor Cerminara is a longtime professor of law with the NSU Shepherd Broad College of Law. She obtained her J.D. law degree, magna cum laude, from the University of Pittsburgh, and earned both her LLM master's degree and her JSD doctorate of law degree from Columbia University. Professor Cerminara teaches both at the NSU Law School and in the HPD programs, and has written and lectured extensively on the special legal, ethical, and practical issues surrounding patients' rights and end-of-life decision-making, all of which are highly relevant to our discussion today. So hello, Professor Cerminara, and welcome.
Hi, thank you.
Professor, can we start by having you tell us why this topic is so important to those providing care to geriatric patients and managing the affairs of older adults?
Yes. The elderly population is particularly in Florida, in a number of different situations. Some of them are surrounded by family and, in fact, are part of a community within their homes or near their homes when there are multiple generations of family who are all involved in most of the family decision-making. Others are here alone. They've moved here to retire from some other place, and all of their children may be far away, or there may be one person here in person with the rest of their children and other families scattered across the country and relying on the person that's in Florida to take care of the elder. This elder caring coordination is a method of dispute resolution that can facilitate discussions among all those family members and or any other people who are involved in high conflict situations that involve the elderly's health.
For our podcast audience, would you share what is it that today's healthcare professionals in particular and caregivers should know about this subject?
The Elder Caring Coordination Initiative was actually begun by an Association for Conflict Resolution. This is a dispute resolution process. It was called, the coordination was begun through Elder Justice Initiative on Elder Caring Coordination. That was intended to be used in high conflict cases where a specialized coordinator, someone who has elder caring coordination training, assists elders, legally authorized decision makers, and others who are going to try to talk through and resolve family disputes, considering, of course, the elder's need for autonomy and self-determination, participation in their own decision-making, and safety, which is one of the key concerns, especially with the elderly who are living alone here. Elder caring coordination can assist the elders, the family members, those other parties in a number of different ways and can offer actually an additional source of support to the elderly person during this time of their life.
How do you see this process and these activities as helpful to support families and caregivers in the avoidance of and resolution of internal conflicts, and perhaps even the avoidance of judicial proceedings or legal proceedings?
So as elder caring coordination has been studied thus far, it's this alternative dispute resolution that has been tested within judicial settings. Right? There has been a situation in which a court might be approached for designation of guardianship, or hopefully, before depriving an elder entirely of their autonomy and self-determination, a court might be approached with regard to specific individual decisions that someone in the elder's life is making, the management of a trust, or a particular medical care decision being made by a healthcare surrogate who's been appointed by the elder, for example. The study that was done occurred in cases that had already somehow appeared in a judicial setting, which everyone would like to avoid, of course, if possible. The result, right, given that these people were already in a judicial setting and thus extremely high conflict, were significantly fewer motions to the court. And when filed, the motions were more focused on legal rather than non-legal issues. Non-legal being something such as, I don't like that particular caregiver who's coming into mom's home, or disagreement about what nursing home mom should be sent to. In addition, incapacity determinations can be safely avoided if everyone is resolving disputes with regard to something that an elder has expressed a preference for. Right? It may not be that that elder is incapacitated, but the best way to overwhelm their autonomy would be to argue that they are. All of that can be avoided with a dispute resolution process about that decision. It also allows these families to act quickly, more quickly than if they were to go to court, and privately, whereas court is very public, as we all know.
Sounds complicated and potentially expensive, Professor. How do you think this will have an impact on, or what impact would this have on the costs of care for our elders and this kind of activity?
There's no doubt that fees are involved. The elder caring coordinator can provide services much as a mediator, even though these are not mediators. It's a different type of training, but they can provide services much as a mediator can. And of course, mediators charge. Any alternative dispute resolution process costs something for the expertise that's involved in guiding the discussion. However, here in Florida, under a statute that provides that a court that has been approached with a high conflict situation specifically has the power to authorize an elder caring coordination session to take place, the statute provides that the parties that are involved are to equally share the cost. And in fact, for the people who might have fewer resources than perhaps the people on the other side of an argument, the statute provides that a court can take into account income, financial assets, other sorts of obligations that exist financially for one of the parties in determining what the split of the payment responsibilities will be. Finally, there are actually some grants available for this sort of activity, and it's possible that this sort of activity will eventually be paid for by covering entities such as health insurance companies, much in the same way that Medicaid, for example, now pays for housing assistance in some cases because it's been recognized as a matter of health. there was a grant that was part of the Elder Justice Initiative project that paid for a significant number of low-income participants in the processes. The grant was provided by a health insurance company in explicit recognition that having this conflict present within their family actually affects the health and the health outcomes of elders.
Going forward, how do you see this effort towards care coordination as potentially being expanded beyond the geriatric populations, but also to non-geriatric patients, healthcare settings as well?
Certainly, elder caring is not necessarily limited to the elders, right? Care coordination could be appropriate for intensely ill people, for people who require a long course of treatment, who are in continuing situations of disability, for example, and might need assistance of the same kind that an elder might need, placement in a different sort of facility, decisions being made occasionally to have care in the home. The current research that I've just been discussing has all taken place within the judicial setting. Some judges won't order elder caring coordination without statutory authorization. Some judges are perfectly comfortable doing so because judges have general power to manage their courtroom and to order those sorts of activities in an attempt to resolve disputes that are before them. It would be great if this went beyond that judicial setting for both elders and potentially these other people who might have high conflict issues arise about their medical care. If facilities were to make available elder caring coordination, if it did become a health insurance benefit that people could call upon, because of the recognition that all of this does affect the health of the person whose life is being decided, that I think would be a really productive way to move forward.
Well, in terms of education and other resources, where do you suggest interested parties might go in furtherance of this subject?
The Association for Conflict Resolution of the Associations of Family and Conciliation Courts have some information online about this particular elder justice initiative. In addition, continuing education is planned. The people who are involved in dispute resolution efforts and who are creating the training courses for these sorts of experts would like to create trainings in the name of continuing education for medical professionals and also for families to consider as they are thinking about the family member who's up in Iowa and ready to fly into town to object to care decisions. Right? It would be nice to have an awareness that this procedure might be available to resolve the disputes that person might be bringing with them.
Well, thank you very much, Professor, and thank you to our audience for joining us today. Please stay tuned for upcoming topics from our renowned subject matter experts.